Ladies and gentlemen, gentlemen and ladies and gents, we're going to start this off just with a little bit of Ray Goodman and Brown. Look, I'm going to turn that volume down because y'all don't need to be listening to that much of Ray Goodman and Cuba Gooding Jr. We're going to let this audio play, okay? And I'll get back with you. This is a mediation hearing that happened today.
Welcome. This service is provided by freeconferencecall.com. Please enter your access code followed by the pound or hash sign. If you are the host, press star now. Otherwise, please announce yourself.
This is Eon.
Hello? Eon.
We've been calling in, and all we got was music.
Okay, well now you have more than music. You now have us.
Okay.
So happy days here, Eon. Okay, I am Rick Barrier, the mediator, and your name is, can you spell your name, or what is your name?
My name is Eon, 2 E's, O-N.
Okay, I need to report his name and address all to the state. Is that your formal name, or is that a nickname, or something else?
That is my full name, sir.
Your full name, okay. What's your address?
The address is 18429 Veterans Memorial Drive East.
Drive East, okay.
Unit 1840, Unit 1874, excuse me. That is Bonnie Lake, Washington.
Lake Washington.
Bonnie Lake, Washington.
Bonnie Lake. Bonnie Lake, Washington. Okay. Bonnie Lake, Washington. And what's your zip?
I don't do zip codes, sir.
How do you get mail?
The post office delivers mail without zip codes. Zip codes are not necessary per the postal manual.
Okay. But that's a lot of things unusual here. Where is this Jennifer? Do you have her there?
Jennifer is here. She will not be talking.
She will not talk at all?
She will not.
And there's a reason she won't talk at all?
Oh, because I just told you she will not be talking.
We actually have an interpreter lined up so we can help her.
No. Your interpreter will interpret for her, but she will not be communicating with you.
I think she needs to communicate with us.
Okay, I just sent you a copy of your own rule. I would strongly suggest that you all review the procedures for this. She can elect...
I'm not talking about rules. I'm talking about what's a reasonable thing in mediation.
Oh, I know. I'm telling you reasonable. We're going by your regulations.
There'll be questions coming up perhaps only she can answer.
If that is the case, we'll take care of it when that arises. But for the moment, Jennifer will not be talking.
Do you have a power of attorney that you sent us?
Yes, you guys already have it. That's the reason why I've been doing all the talking.
So this is... I'm sorry, that's very rude. Kim, this is attorney for the lender.
I haven't received any power of attorney showing that Kim Hood is representing anyone. I've asked her for that. On several occasions, and she hasn't sent that to us.
So I'm an actual attorney, so I don't have to have a power of attorney to act on someone's
Yes,
behalf?
you do have to have a contract to act on someone else's behalf.
An attorney for the borrower has authority to
Yes,
act on her
and
behalf.
in order for them to act on behalf of anyone, there needs to be a written agreement. That's what we're asking for. The same as you asked for one concerning me, and we provided that when they demanded it of me. I asked for that immediately. I do that all the time.
You're not going to get it. And
Excuse me? I'm sorry, what did you say? Did you say that I didn't have the right to it?
no, I said you're not going to do
No, I didn't. No. It appears that you're saying I didn't have the right to request such information.
You have right to request if you want.
Oh, okay. It looked like you were trying to give me legal advice by telling me that I wasn't going to get something I had the right to, and you were talking about acting in bad faith. You're coming at me with an attitude, and I really am thinking that this conversation shouldn't be that way. It's supposed to be mediation. It's supposed to be fairness on both sides. So if she's going to be representing another party, she has to have some sort of proof showing that she represents that party. And yes, I do have the right to demand, because we're talking about confidential and personal information. So yes, I have the right to demand that.
Okay. Well, as I already mentioned, I'm not giving you a
I did not see that in writing. I've been waiting for it. I mean, I keep getting these letters with your signature on it, but I don't see anything from the actual party of interest. And in order for you to represent that party of interest, there has to be some sort of authorization. I don't see the authorization on file. I don't see it from any of the actual officers of the corporation saying that you are allowed to speak on their behalf. So until that time, I cannot sit up here and communicate with you on their behalf. So we can continue.
So,
I can't communicate with you, miss.
are you going to just...
I can't communicate with you, miss. I can communicate with the mediator. You can talk to him.
So, I am...
I cannot communicate with you directly, miss.
She's talking to me now.
I'm not talking
Oh,
to
okay.
you.
I'm sorry.
So go ahead, you're
I am making a formal objection that no other party is present today. The statute, RCW 6124, requires an in-person appearance. If a person chooses to have a power of attorney, which is allowed under the statute, you are correct. A power of attorney is allowed whoever. However, there is no excuse for that person not being present today. Someone must be present. So that means no mediation session can occur, which means I'm requesting that the mediation be closed, certified, and the house will go to sale unless I hear from Jennifer during this process, and if a person appears in person, which is required. A power of attorney doesn't mean you get to call in on a phone line.
Oh, okay, thank you for clarifying that. So yeah, yes, I don't know if you heard what she was saying, but basically, what Kim is saying is that, that's the way I read the rule too, is that the rule says certainly a power of attorney can represent a party in this mediation, but it does not say that they do not have to be present.
Let me read it to you if you don't mind.
Always have it.
I'll read it to you. RCW 6124-163, number 8, number A, lowercase, states, a person with the authority to agree for resolution on behalf of the beneficiary and or other parties may be present over the telephone via video conference during the mediation session.
Yes, that is true, and
Okay.
was the beneficiary in this case.
Okay, but hold on. When a borrower named in a loan is unable or does not want to attend the mediation in person, he or she may authorize a representative to act on his or her behalf.
Yes,
Okay, thank you.
that's true.
That's what's going on here.
And so the person representing her on their behalf is expected to be here.
Not
That's
if I'm in
what-
California, it's not the case. That's telephonic
We're in
conference.
Washington. I'm sorry.
I'm in
We're
California.
in Washington. You're in California. I thought you Bonnie.
No, you asked for an address. That is my mailing address.
Ah, okay. You live somewhere else then.
I'm in California.
Where's Jennifer right now?
That's not the case, sir. That's not what we're talking about. We're talking about whether or not the individual can appear via telephone. That's what we're doing.
Okay.
So, Rick, I just wanted to address that the statute says that the beneficiary may have a representative telephonically or other means appear. The beneficiary in this case is not Eon and it's not Jennifer. So that the statute authorizes the bank's beneficiary, the bank's representative to appear by phone. I, however, as attorney for the bank, am required to be here in person, which is the same responsibility that the borrower must also oblige by. They must have someone in person.
Okay, so what you're saying, Jan, is that the lender, the bank, they can be represented by an attorney, and if they are, the attorney has to be present. The reason it's set up that way is because the bank usually has their headquarters or their processing people somewhere else other than here. They're in California, they're in LA, wherever they are, there's different places. So we call in, they call in because it's being practical to fly from Missouri to here for the session.
Yeah.
They have an attorney here to represent them in person, so we can have an in-person discussion, which is generally the best way and the proper way to do mediation, so the parties can look at each other, talk about things, talk to the bank on the phone, because that's as close as they can come. The borrower, however, is expected to be here, or if it's a power of attorney representing them, they're expected to be here also. So that's
what I am reading from right now is the Foreclosure Fairness Program guidelines. And under fairness, the beneficiary cannot have a right that the borrower doesn't. The law provides for equal protection of law. And this mediation is supposed to be fair and unbiased towards both sides. And as I told you, there is a section. You go simply to page 18 of that document, and you will see that it does say the borrower does not have to be here in person. Second paragraph of the paragraph that was sent to us saying that the borrower had to be there in person.
Okay, yeah, let me suggest this.
Yeah.
I would like to, I'd like to see, I believe there's some irregularities in our process so far, and there's a question whether this will be considered a mediation session or not, that Kim mentioned, but while we're here, I'd like to at least maybe share some information and talk a little bit about Jennifer and her situation. I mean,
I would rather we talk about the fact that we were supposed to receive documents, and according to this procedure, that there was supposed to be a sharing of documents. We've done our due diligence. We provided everything that's been asked for, even when it wasn't within the time frames. We were given statute of limitations that weren't incorrect. That were very incorrect. We still provided that information. As soon as we were made aware of it, we provided it. But we have not received what we've asked for. And I don't want to miss this fact right here. I gave you this section, and I'll read it again. When a borrower named in a loan is unable or does not want to attend the mediation in person, I don't want to make an issue of this, but I have to because this is what the rules allow for.
well, okay, so now you said you didn't receive information from the bank. I've seen extensive information that the banks provided.
I didn't say that they didn't send us paperwork. No, they didn't send us what we asked for.
Well, what did you ask for?
Well, see, they were claiming that there is money owed. We have information from Fannie Mae that first, they don't sell their loans to anyone. And second, if the loan has been... Hold on, you asked me what I asked for, and I was explaining.
Okay, go ahead.
They don't loan, they do not sell, they do not trade their mortgages to anyone. And that this loan was paid off 2011, December of 2011. So since they said that there was an amount owing, we asked them for chain of custody and for a complete comprehensive accounting certified. They've given us an accounting, but it's been a statement. Not certified, not validated, not verified. And it's only from 2015, 2016, 2017. Of course, you know we can't go with that because we have no starting point. We have no way of knowing how much they've actually documented they've received and whether or not they're actually due any money.
So did the debt disappear, you think? I'm trying to understand how.
Oh, no, not disappeared. We're trying to validate it. We're trying to validate the amount they're saying is owed. There is a discrepancy. They're saying that they're owed. We're saying, no, they're not. We're saying that this was paid off 2011. They're saying it's not. So we asked them for an accounting.
Did Jennifer pay off the loan in 2011?
Oh, no. Fannie Mae has the documentation that the loan was paid off. So that's why we needed, that's why we needed a chain of custody to show that they are actually the party whom they are claiming to be. They're claiming to be the beneficiary. That means they have to show some verifiable proof. This was a government-secured loan. That means the FHA is involved. You guys, your whole law is set up under the Non-Judicial Foreclosure Act. The Non-Judicial Foreclosure Act specifically requires that there be an FHA letter put into the record before they can start foreclosure proceedings on an FHA home. Well, that hasn't happened. We don't see that letter anywhere, so we've asked for it, and we haven't received it. These are documents that, as custodians of record, and because it is involving this process, and it is involving the amount claimed owed, we have a right to. They haven't sent it to us. We've asked for it 5 times. 5 times, and have not received it. Have not received, well, sir, we can't provide that to you. Sir, you don't have a right to it. No, they just simply haven't sent it to us.
Okay, so, let me ask you a question.
Yes, sir.
Does Jennifer want to keep her house?
Oh, of course she does. We just want to finish this administrative process first.
Okay. And your expectation to come out of this process that she won't owe any money?
No, the expectation is so that we can verify and validate the amount that's actually owed, because we're not agreeing to the amount that they're claiming, because our figures don't match up with theirs, and so we need the accounting, certified accounting, that, so that we can proceed, so that we can go ahead and make the arrangements for paying, mediation, modification, whatever is necessary to get this matter resolved.
So what would your record show then? Yeah?
Oh, no. We can't do our records because they are the custodian of records. Our records show that Fannie Mae shows quite different. That this matter has been.
Records are different.
I know. That's why we need to see theirs so that we can do the math.
So what does your show? How
That's,
does it show that she
but
owes?
see, that's what I'm saying. We've already provided that information to you. That's the documentation that Jennifer has already provided to you. So now we needed them to follow up on their end so that we can compare figures.
Okay, so I haven't looked through all the paperwork, but did they send something from Jennifer that said that she thought her balance was, $200,000
Well,
to take her out? Or?
No, what we didn't receive is we didn't receive any type of comprehensive accounting from them. We have a right to that information. I would love to switch the burden to Jennifer now, but we can't do that. We're switching the burden to, we requested this information. We had a right to request this information, and they have not given us a reason as to why they have not supplied the information that was due according to the statute within 30 days.
Okay, what information has
I just explained it.
the
The comprehensive accounting. They only gave it to us from 2015 to 2017. That's not a complete accounting. Nobody can write up any figures on that. If we go from 2015 to 2017, we accept that as the actual accounting, then we can only go by the figures that's there. And if we do the math on the figures that's there, it's definitely not going to come out to what they're claiming they're owed. So we need the actual accounting.
Let me ask Kim, do we have a tally from the transfer?
So there's 2 issues. The first one is that this has already been responded to separately in a debt validation request, which has already been mailed out even before the mediation process started. The debt validation request went out. That was remailed by Victoria here at the DRC to Jennifer via USPS. In addition, we provided the statutory required documents, which are outlined under the mediation program. So just because someone doesn't get what they want doesn't mean they didn't get what they were entitled to.
So it sounds like, that the information, at least the information you requested, has been provided in writing. There's a debt history or whatever certification. So I'm not sure that it may not be exactly what you would like to have, but I think it meets the statutory requirements.
No, because I told you it's only from 2015 to 2017, and I assure you that doesn't meet the statutory requirements, because the statutory requirement says that this matter involves the Non-Judicial Foreclosure Act and the other federal laws that are hereby associated to this particular statute. Remember, this statute does not supersede the Non-Judicial Foreclosure Act. Second, she's claiming that they've supplied everything we've asked for, including proof that she represents the bank. She has not. And they... Yeah.
You need to let that one go. I mean,
Oh, I can't.
She is attorney for the bank.
I can't let that go, because we have the right to that information, and you have not given me a single law or anything in this code that says we don't have a right to that information. And that's what I'm asking for, and you haven't said anything in this code that says we do not have a right to that information. You asked me for a power of attorney, and this actual statute requires a power of attorney be on file. The courts require a power of attorney be on file when somebody enters in court representing another party, whether it's a corporation or a person. And once a person asks for that information, they have the right to receive it.
I may be wrong, but I believe attorneys show up in court all the time representing people.
Yes.
Without a power of attorney.
Sir, when it is requested that they produce that power of attorney, they produce the power of attorney. I can show you I can send you several power of attorneys that I've asked for on the record in court and have been supplied to me.
In California.
Maybe there, but in any event, let me ask you a question, Kim. Do we want to get the bank involved, or is it?
No, I'm not going to ask my client to disclose any personal information to someone who has not actually appeared today. So I'm not able to do that. So I would request that, since no one has appeared today, that this be closed and certified.
Okay, I'll definitely consider that. So what's...
Okay, let me go ahead, and I think we can do something better here. The law, and I'm just going through the letter that was sent, and it does mention any other loss mitigation guidelines for loans insured by the Federal Housing Administration. This
isn't an FHA loan.
I'm sorry, I am sorry, ladies and gentlemen, let me finish, please.
Go ahead.
Okay. The document that I'm reading from is the foreclosure mediation session scheduling notice dated July 26, 2017. I want all of you to know that this is a Federal Housing Administration loan. This housing loan is associated with a HUD-1 form. This was a government-secured loan from the onset. This loan started with Fannie Mae. This is a government-secured loan. This loan has with it mortgage insurance. A default has been documented. A deed of trust has been introduced into this proceeding as evidence. The deed of trust on page 2, section N, speaks as to the mortgage insurance. Page 9, section 10, speaks as to the mortgage insurance. We need to know when the claim for mortgage insurance was denied.
I can't respond because this is actually nonsensical at this point, and there's no reason that you think that a mortgage insurance covers you not paying.
So the issue there is, I guess, whether the mortgage insurance is to protect the lender, not the borrower.
I'm sorry, the mortgage insurance is there to protect the borrower and the lender. It's the borrower who pays the mortgage insurance.
I would love to think that, but it sure hasn't been my case. I've been through a few foreclosures myself, and nobody picked up my mortgage insurance. So I think you've got a good insurance salesman if you can get a program like that. Yes, sir.
Mr. Rick, I apologize, but what I'd like to have everyone focus on is section N of the deed of trust, if you would mind turning to that so I can show you what the mortgage insurance is for. According to that contract, because the deed of trust is the contract for which these whole proceedings are proceeding from.
Watch it. why don't you read me section N? I don't have it in front of me right now, so read what it says.
Okay, give me a second to scroll down to that section of the document. I
Sure,
have it
no problem.
documented here, but I have to go slow because it's in PDF form, and if I go too fast, it won't pull up. I have to wait for the page. I'm going to read it. No, that's the adjustable rider. Give me a second to pull up the actual.
Sure. Come on, sure.
Sorry, there's a lot of documents in this particular matter, and so pulling up, having this in front of me at the same time while looking at my PDF viewer is not the easiest thing. Now I got to find out what page it's on. So if you can go ahead, and I'll let you know when I found it, when I found that actual page. It's supposed to be at the top. And you don't have the deed of trust in front of you?
I do have it. I can provide it.
I think Kim said she had it. Let's see if I can find that here. And we'll see what it says.
Roughly about page 2 of the deed of trust, section N, as in Nancy.
It talks about title insurance?
It talks about
mortgage insurance?
mortgage insurance. And it tells you in that section what mortgage insurance is for. And I can tell it to you verbatim, but it'd be better if somebody read it word for word.
I'll take a look. Yeah, mortgage insurance means insurance protecting lender against the non-payment of or default on the loan.
So if there's a default, yes, that's exactly the point. If there's a default, the lender has the option of mortgage insurance. We need to see where the insurance has been denied.
Well, they have not asked for it yet, probably because the bank has been trying to get this loan to be modified and keep getting the payments so the person can stay in the house.
Yes, but they issued a notice. They issued a notice of default. Notice of default is the beginning process for the insurance.
The beginning process for getting someone out of the house.
No. It's the beginning process for a start. Yes, it does, because pay attention. In case of default, the notice of default is to collect the insurance. That's not to get the borrower out of the house. No, see, to get the borrower out of the house is so that they can recoup the monies that they're claiming they've lost. That's what the insurance is for. That's the explicit definition that you just read, that the insurance is for. It's to protect the lender should the borrower default. They issued a notice of default. That's the process for filing a claim with the insurance company per the insurance policy.
Sure. If they default on the loan, which means that they have been foreclosed on.
No, it doesn't mean that they've been foreclosed on. It means that they have, that there is a default.
That's a rather ludicrous concept there, yeah,
I appreciate it. I appreciate that you think it's ludicrous, but if you look at, I have it right here, under N, mortgage insurance means insurance protecting the lender. This is insurance. If a person gets into an accident, they don't wait until after a court case to collect on the insurance. The insurance is collected once a claim is filed, once the accident has occurred.
I think you're mixing apples and oranges, because
no.
If you buy insurance for your car, you get reimbursed if it wrecks, right? That's what happens.
No,
right? That's why you have insurance.
Insurance, the other party gets reimbursed, not you.
If I wreck my car, I'll get reimbursed, right?
No, the other party whose car you damaged gets reimbursed.
No, I just ran into a tree, that's what I'm saying. Insurance will pay, my collision insurance will pay something, okay?
Yeah, the collision part of it, yeah.
Money comes to me, so...
Yes, but you have to file a claim.
See, if you're talking about comparing cars to the house, what it amounts to is if you owe, say you have $20,000 on a car loan,
yeah,
and you had an accident, does the bank get the $20,000? No, you get it and you fix it, right? And
no, if you owe money on the car, the bank gets it first. The first lien holder gets it.
They get it repaired. That's what they do.
No, the first lien holder gets the money. I've been in that situation before.
Let me just, if I don't mind, let me just say that maybe we can respectfully disagree on your interpretation of Section N. Okay?
Well, go to page 8, number 10. it goes ahead and gives you more detail. Section N is only a highlight point. Section number 10
Right.
explains it in detail.
Section, which section?
Page 8, number 10.
Okay, well, let's see here what that has to say.
See, what nobody is paying attention to, Jennifer is the one who's paid the insurance, but the beneficiary is the one holding the policy.
So you make the payments of any reason, she's available, blah, 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 blah. Unavailable, except either take okay. If the statutory equivalent mortgage insurance is not available, shall continue to pay when the amount of separately designated payments are due when the insurance ceased. Except those assaults shall be non-refundable, if notwithstanding the fact that loan assaults may pay in full, the lender shall not be required to pay more any interest or earnings on such assaults no longer requires or payments if mortgage insurance. Other insurance becomes available is obtained and then requires separate designated payments towards the premium sure applies all kind of ability in order to make the premiums required to maintain for non-refundable. Yeah, I don't see anything
Now,
else.
read that very next paragraph, and that will explain what my point is.
Which paragraph?
Mortgage insurance reimburses the lender or any entity that purchased the note for certain losses that may incur if the borrower does not pay the loan as agreed. The borrower is not a party to the mortgage insurance, which means that they are responsible for filing the claim. We are asking, has a claim been filed and has it been denied? We need to seek proof because there has been a claim of default.
Well, a very interesting approach, but...
this is the contract. This is not an approach. This is the actual agreement by which we are here today. If it is not for this agreement, these proceedings don't take place. This is the contract.
I think we're not going to get very far. Now, does Jennifer know what you're doing? Does she know?
Oh, please, sir. Look, when I explain things to Jennifer at first, because again, English is not her first language, I have to spend a lot of time going over this with her, explaining it to her in detail so that she gets it. She doesn't always get it right away, but she understands what's going on.
So let me ask this. I mean, we had an interpreter on that for a day,
I know.
But we can't talk to Jennifer, right? So where's
No.
Jennifer?
Jennifer is okay. She's doing fine.
Where is she? Where is she?
I need to focus on the mortgage insurance.
Where's Jennifer?
Sir, I need to focus on the mortgage insurance.
I'd like to know where Jennifer is.
I'm here on Jennifer's behalf. She has authorized me to speak on her behalf, and that's what I'm here to do.
If this process continues like this, I'm pretty sure that she'll end up being foreclosed on. So I don't want to
Sir, she can't end up being foreclosed on because I will immediately file an appeal of any negative decision since we've already determined we have not received the information we've asked for. We had a right to the financials. We haven't received them. This is a due process procedure. Are you telling me we don't have a right to the financials?
I'm telling you that you've gotten the information.
Okay, can you please show me the financials from the time they collected this loan, since they said that they were the holders in due course? Show me the financials for 2011, 2012, 2013, 2014. And that resolves that matter.
Yeah, that was a couple of years ago, I think.
Sir, a couple of years ago?
I noticed that Jennifer...
Wait, I'm sorry, you said it was given a couple of years ago?
Yeah.
This process didn't start a couple of years ago. This process started the 21st of June.
This process started probably 2011.
No, sir. These proceedings are stemming from a letter, a default notice received in June, not in 2015, 14, or 13.
Well, if you look back in the history...
I cannot do the history because we didn't ask for this back then. We asked for this now. And according to the rules, we're required to have them now, not back then.
My point is, back then, what was given was the history up until 15, and what you got is the remaining part.
No, we did not receive anything up until 2015. Please don't do that. If we received it, show me where we received it. I don't see it anyplace. I don't see it in my files. I don't see it in the response to the letter. So if we received it in 2015, what's the problem with supplying it now?
Okay, so there was a debt validation.
It has nothing to do with this process here.
No, it's the same loan.
No, it may be the same loan, but it has nothing to do with these proceedings here and this statute. This statute and that process, two different statutes, two different processes. We're talking about this process, these proceedings. We're not talking about any other issue. If I wanted to speak with you about our debt validation process with him, then we would really be into a really deep conversation as to what the FDCPA requires, since they list on their letters that they are a debt collector. But we are not here to discuss that. FDCPA, the Fair Debt Collections Practices Act. We're not here to talk about that. That's why I didn't bring it up. We're talking about the Washington statute and the Non-Judicial Foreclosure Act, the two most applicable acts in these proceedings.
Okay, yeah, let me just give you just a brief comment or statement about how this mediation process works here. And generally, just
as outlined by
bear
statute?
with me. Bear with me. The purpose of the mediation is for the bank to discuss with the borrower alternative ways to deal with the existing mortgage. And it can be a modified loan, it could be a reinstatement if somebody hasn't made a pay loan current. If it's not one of those, then the discussion turns to non-retention options, which include foreclosure or a deed in lieu of foreclosure or a short sale. Now I noticed in 2015, Jennifer attempted a short sale on her house.
You were telling me about this process. I didn't want to talk about 2015. You were explaining to me about this process, and I'm willing to listen.
I'm just explaining that she's been through some of this process.
But we're not talking about that. That had nothing to do with me. That has nothing to do with what we're talking about right now. This is a new proceeding. This is not an old proceeding. This is not a continuation. There is a procedure for a continuation of a mediation proceeding. This is not one of those meetings. So we are not here to deal with that because it has nothing to do with this meeting. But what I can tell you, that you talked about the options to the borrower. One of the options to the borrower is mortgage insurance, because the borrower paid the insurance. Now, if they're willing...
I hate to tell you, you're just plain wrong, but you're just plain wrong.
I know, you're saying I'm wrong, but I'm looking at the contract.
You are wrong.
I'm looking at the contract. Are you telling me the contract does not have mortgage insurance associated with it? Are you telling me that Jennifer did not pay the mortgage insurance?
I'm telling you.
That's why we want the finances, because the finances show that the insurance was paid. That's what we're asking for. You're telling me that the insurance has nothing to do with this. And I'm saying, well, yes, it does. It's part of the contract.
I just feel sorry for Jennifer, that's all.
Okay, sir. I'm asking you again about the mortgage insurance, which reimburses the lender.
No, that's all BS, and you know it. So
Excuse me. What did you just say? And you are a public official, and you're doing what?
I'm not a public official. I'm a private mediator.
Sir, you're not a private mediator. You're representing the state of Washington in these mediation proceedings. You're not private. You're representing the state of Washington.
All right.
That's why you are permitted, you are required to follow the statute.
I think we've done that pretty well. We've set up the session, and we have...
No. You've been going through the motion. We have not exchanged documents because I told you we have not received the financials. You just indicated that the financials exist. So why haven't we received them?
You've received the documentation of the debt.
No, we have not. That includes certification of this debt. That doesn't include somebody just writing a bunch of numbers on a piece of paper that are not certified and are signed by an officer who is a CPA or a similar officer of the organization. That's not certification. And we have a right to certifying the debt.
Well, let me just make a comment. I've probably been involved in, 150 of these mediations.
Sir, I'm not talking about mediation. I'm talking about the law. You're talking about a process. I'm talking about what the law requires. Your statute requires this.
what I'm talking about is that in those 150 mediations, the bank has historically, in every case, provided information on the status of the loan, the current amount due, the principal, the cost, whatever interest, and with amount to reimburse or reinstate.
So you're saying we do not have the right to ask for a certified copy of the accounting to verify the amount that's owed?
I'm saying that the banks have always provided
a certified copy of the accounting.
It's been accepted by the borrower.
No, I'm sorry. Are you saying that they provided certified copies?
It provided information from their accounting system.
Their accounting system. That's interesting. I'm asking for certification because of the amount that is claimed due. Do we not have the right to ask for a certified copy, especially since all we got was 2015, 2017?
I don't even know what certification would be in this case.
Certification means the CPA actually does the accounting, showing where every penny, where everything has been and has not been going to. Again, mortgage insurance premiums are associated with each payment. We just read that in the contract. If mortgage insurance has been paid for by the borrower, then they have a right to validate the fact as whether or not a claim has been made, because the insurance is being paid for to protect the lender should the borrower default.
Okay, just a second.
You guys are whispering to each other. This is not supposed to be ex parte proceeding.
It can be. You and I can have a discussion. I can have a discussion with the other parties.
No, because this is fairness. This is fairness. You cannot sit up there and take sides of one party over another.
Do you understand mediation?
I fully understand mediation.
Just a second. I'll be right back.
The mediator just walked out to take a private phone call.
Yes, I heard his phone ringing. I could still pretty much hear him in the background. But yes, I thank you for saying that. I appreciate that.
Wish me a happy birthday. Today's my birthday.
Happy birthday. Oh, happy birthday.
Everybody celebrates my birthday.
Yeah, happy birthday.
Yeah.
Oh God, I am so sorry. I just realized it's the 11th of September. I really am so sorry.
It's okay. It's like being, born on Christmas or something.
Yeah, because you couldn't choose this day even if you wanted to. So yes, I understand.
Yeah. There we go. Anyway, I gotta get anyway, I'm sorry. I'm gonna take that because you want to wish your birthday. Well, I think at this point, I don't think we're going to get too far. I think the mediation process is not going to work for you because you will not accept what has been submitted.
Excuse me? Are you telling me that what's been submitted was what was requested?
Yes, what was required, yes.
No. Sorry. The law did not require them to send us a partial accounting. You just admitted that the full accounting was available. And they did not provide that. 2 years ago. This is not 2 years ago.
Okay, just a second. I wanted to talk to you.
I just wanted to be clear that, again, I think that really these concerns now lay outside of mediation, which is why I don't think a session has occurred today, because we don't have anyone present. As far as requesting an accounting from anything further than the date of default,
I'm sorry, that's a different conversation. My conversation with him right now was different. You interrupted that conversation. I was asking a question.
No, everyone's listened to you. So
No, I was asking a question. It wasn't somebody listening to me. It was me asking a question, and you just interrupted him responding to my question. Again, are you saying that the accounting that we've asked for is complete?
You got...
Not you. I'm not talking to you. My question wasn't to you. Please stop interrupting me. Please stop interrupting me. I asked a simple question.
Okay, so basically, what you're saying is from
No, not what she's saying. You were saying that we received everything we were entitled to.
I believe you have.
Okay, now I'm going to ask you again. Are you saying that we received the accounting from 2011 when they took over this loan until present, which is what the statute requires?
The statute requires...
Would you please stop interrupting? I'm not talking to you.
Okay, no, she's talking to me.
I'm talking to the mediator, and if you were here, you
But then you should let him answer the question, not you answer the question for him. God.
You have to be provided financial information from the date of default, and you've received that. So.
Excuse me, it says financial information from the date of default.
Yes.
Please take a look at that again, because it doesn't say that.
It says 1 year or since date of default, whatever is longer.
Where are you guys reading from? Hold on, because if I'm incorrect, I don't mind correcting myself. So let me know what part of the code are you reading from, or the procedures.
Okay, what's the answer on that?
I suggest that you read the statutes.
I have the procedures right here. Which part of the procedures are you reading from?
Why don't you go ahead and just start reading them, and I'll tell you when you get there.
Oh, so you want to be, okay. I can't talk with that character anymore, okay? You guys are quoting a law to me, and I'm asking you, where is it? And you're sitting up here playing games with me.
No, don't play games.
That character right there just told me to start reading from the beginning until I get there. And then I've shown you everything I've talked about. So please don't tell me you're not playing games.
I don't know the games. I think she's probably getting a little tired.
Then that's okay. This is a mediation hearing. She can't get tired. We haven't even been on the phone for 50 minutes. She can't be tired. It's not the longest mediation you've ever had. We're supposed to be working out an agreement here, aren't we? And we haven't even talked about anything.
I'm sorry, the statute's pretty short.
Again, I asked this young man for the information. I told you I'm not talking to you.
Well, then you can't participate.
I told you I am not talking to you.
I'm done. I'm done. He's not here.
I told you I am not talking to you.
I'm done.
Okay. I think,
6124-163. Read it. Goodbye.
Okay, yeah.
Sir, I'm looking at 6124-163. There are section A, B, C, D. Which section are you reading from?
How many sections are
Like I said, I'm looking at your procedures because that's what I'm going by, because if I went by the entire code, we'd be reading for days. But I'm looking at your procedures. I told you I have them pulled up. Foreclosure Fairness Program Guidelines. That's what I'm looking at.
That's not a statute.
Oh, God,
read
would you...
the statute. 61
Okay.
24 163.
Sir, she said she was done, and now she keeps interrupting. She needs to stop interrupting.
Okay, you have maybe 30 more seconds before I'm leaving.
It doesn't matter,
If
Miss.
you have anything further to say,
I have nothing further to say to you. Like I said, I need to receive the accounting. The law requires that we receive that information.
Read it to me. Read it.
Mr. Rick, I did tell you that I cannot speak to that woman. She has not provided any proof of standing, and we've asked for that at the beginning.
She has proof of standing as far as I'm concerned.
No, as far as you're concerned, but legally she does not have proof of standing because she's not provided any documents saying she's represented that entity, which the first thing you asked me for was proof of my ability to be here.
That's because you're not an attorney and you're not...
I'm sorry. Do I have to be an attorney? Because according to the state of New York, I'm recognized as one admitted to practice law there. So I'm sorry. Do I have to be an attorney?
Yes, you do actually.
You need to shut up. I apologize for the frankness of that, but I've asked her to stop interrupting me.
It's about time that we're hearing, so Thanks for joining us.
No, I need to ask you one further question. What is your appeal process? No, I'm asking you a question, sir, again. What is the appeal process for this procedure?
I don't know there is any. I mean, it's a
This is
process.
an administrative proceeding. You're telling me you don't know what the process is once you make a decision?
Well, the program is designed for people who work with the bank to try to get a modification.
No, the program is designed for us to work through mediation. And since the beginning, you have been questioning me. We have not gone one step into working on a mediation of anything. I told you we didn't receive certain documentation. You verified that the documentation is available. You have not brought up any information as to why we don't have the right to that information. And I've waited for you to state that.
I suggest that you try to help Jennifer however you can.
No, you're not answering my question. So you've been avoiding my question since the beginning of this conversation.
I haven't avoided anything. I'm sorry.
Okay, so you told me that to go to 6124-163. I'm here. Where is that thing that says that you don't have to provide us any financial information whatsoever? I'm looking for it. I don't see it. You asked how many sections there are? There are over 18 different sections to this particular section of code.
Okay, all right, well listen, I think you probably...
Sir, I asked you for that code. You are the mediator. You mentioned that we didn't have the right to this. You told me it was here. I don't see it.
Yeah, I think we've probably got around a circle.
No, this is not a circle. You told me we did not have a right to it. You told me it was here in a statute. I have the statute in front of me. I understand statutory interpretation. I don't have a problem. But I don't see it. And I was looking at the very same statute as was put in those procedures. So I'm looking for it where it says that you can only provide up to 100 days prior. Can you please tell me where that is in the statute, since you guys claim to have been reading directly from the statute?
What it said, just to clarify, was that you'd have to provide accounting from either a year in the past or
where?
the day of default, whichever it is.
I'm looking for it. I don't see that. Can you tell me where exactly are you reading from?
It's in the, I'll see it here.
The borrower, the beneficiary, authorized agent, and the mediator must meet in person for the mediation session. However, a person with the authority to agree to resolution on behalf of the beneficiary may be present over the telephone. Interesting. That's section 8A. So apparently I was correct.
The beneficiary.
No, it says the borrower, read it again, the borrower, 8A, the borrower, comma, the beneficiary, comma, or the authorized agent. However, a person with authority to agree to resolution on behalf of the beneficiary may be present over the telephone or video conference, and if you look at it previously, my speaking on behalf of the borrower, being in a different state from telephone.
Section A, I think, talks about the second mediation, not the first mediation.
It's okay. I just wanted to tell you that your statute does allow the telephone conferencing, especially when one is not in the state.
Jennifer is. That's the frustrating part. And
no, I'm on her behalf. That's not the frustrating part.
Why?
Because I don't have to be there when I'm in a different state, and I'm speaking on her behalf.
But Jennifer needs to be, I've never had mediation without the borrower being here.
I just read to you that the borrower can elect not to be there. I just read that to you. But I'm looking for that 100 days, because I honestly, I promise you, I don't see it, and I have been looking for it the entire time.
Let me read this here. It's, what section is that? This goes way up. Let's see. 24.163 timelines procedure. So RCW 61.24.163. And if you go down to, see, section 2, 3, or let's see, 20 days since transmit the documents. Okay.
Wait, this thing doesn't have any timeline. This thing says expenses, tax returns from previous years from the borrower, hardship letter information from the borrower. Then that means we have the very same right to receive this information from the other side.
So come on down. It says section, section D, for example. Well, first off, section C, or subsection C, they have to provide proof that the entity claiming to be the beneficiary is the owner of any promissory note. And they provided that.
They have not provided that. The proof,
there's a certified letter,
sir,
certification
the proof of ownership comes with a chain of title, and we've asked for that.
Okay, well,
that's proof of ownership.
The statute does not talk about a chain.
Excuse me, the statute is according to the Non-Judicial Foreclosure Act.
And an itemized statement. And the bank is required to provide the best estimates of the rearage, an itemized statement of the rearages, itemized list of the best estimate of fees and charges, the payment history and schedule for preceding 12 months or since default, whichever is longer.
No. That's F. That's F. We have an itemized list, best estimate of fees and charges. Those don't have a timeline on it.
That'd be for reinstatement. So that would be a lump sum, total.
That doesn't say anything about reinstatement.
Anyway.
No, take a look. It doesn't say anything about reinstatement. How can you do that?
I think we're done.
Excuse me, how can you do that? And look at number G. Are there any timelines on number G?
I think we're done, yeah.
Excuse me, are there any timelines on number G?
There's a timeline on the session, and it's just about over.
There is no timeline on number G, is there?
There's a timeline on the session, and we are done, and I appreciate you showing
Sir,
up.
I asked you a question. Is there a timeline on number G? Which means that you gave me the wrong information.
The answer is the mediation session is over.
So you're denying us our right to a fair hearing.
Whatever you want to call it. That's what it is. You have a good day down there, and take care.
Now, hey, wait. You guys have documented this hearing. You recorded this hearing, didn't you? Uh-oh. Hold on, Jennifer. Jennifer?